Well, good morning, guys. Alex Woods, civil litigator with Redwood Legal Limited. Now, I want to talk to you today about what I think is probably one of the most critical issues if you're thinking of bringing your own claim, or indeed if you're thinking of taking legal advice and you're just weighing up the options and whether you think that your claim is complex such that legal advice really is essential, and it would be best to at least take a little bit of advice from a lawyer. Okay, this is something of a golden rule, and it's something that I learnt from previous solicitors, and I could tell the solicitors who were good from the solicitors who were bad because of this key element. I'm going to outline the facts of a particular case, and I'm going to use it as an example to illustrate my point today. And it's just a fascinating case. It's a case that I got involved with in August. And I'm going to take the perspective actually of my opponent in this case, my opponent instructed solicitors, because I think that's going to be the most helpful way to look at the case for you. Now, the brief facts of the case are they're relatively straightforward. It's a very high value claim. Basically, one businessman lent £60,000 to another businessman somewhere around 10 years ago. And that businessman hasn't repaid the loan. The loan is secured on a property, so the opponent, my opponent's solicitor here, was bringing a claim against my client to, get hold of that property, to possess or to get an order for sale against that property in order to meet the loan. There's a complicating, there always is. Every case is different, and advice is useless advice unless it's tailored to the individual circumstances of the case. But there's an interesting complicating feature here, which is that our clients have a defence, because the opponent, just the lender in this instance, just left the loan unaddressed for a period of, goodness knows, 3-4 years. This was after our client had actually put forward proper intelligent settlement proposals at the point at which they saw that they were going to be unable to repay the loan and were afraid of their house being taken, put forward these settlement proposals which were ignored by the opponent, who then just did nothing for 3 years and let compound interest rack up on the loan. And there he has a defence under the unfair relationships test. It's a head of claim that I've not had much to do with for a number of years, ever since the financial crisis, when I cut my teeth, earned my spurs on financial mis-selling litigation on behalf of businesses and consumers. Anyway, I'm going to leave that out of the vlog today, because most people out there will, want the simple facts, because the simple facts is going to make best sense to you if you're looking at this video. And I'm just going to assume that this is a straightforward debt claim with the added complicating factor of the debt being secured by way of charge on my client's property. Okay, so unfortunately, this particular businessman obviously wanted to cut corners and save money, and out of the blue he decided to pursue this loan over a period of years, and he instructed solicitors in order to bring proceedings. Now, so he actually did take the trouble, thank you very much, he did actually take the trouble to formally instruct lawyers, but I'm afraid to say they didn't do a very good job. He made basically probably one of the worst dog dinners of a claim that I've ever seen brought before a court. They simply brought the claim in completely the wrong way. They brought the claim for an order for sale of the property, which was the wrong way to bring it. There was already a charge secured on the property. They should have just been bringing a claim for possession. They brought the claim Part 8 when there was actually an issue. There was a defence, and I'm not sure whether Part 8 was the appropriate way of proceeding with this claim. For those of you who've watched my video, there's the main way of bringing you watch my vlogs, and for those of you who have watched my vlogs in the past, you'll know that the main way to bring a claim is by Part 7, but there are certain complex a certain category of claims that have actually to be brought by the special Part 8 procedure. So there was a debate over that. As I say, there was a defence, and the witness statement that they produced in their Part 8 claim was full of holes, and essentially the judge was extremely sympathetic to them, actually, because at the hearing we didn't formally go, we actually provided legal advice and drafted statements and basically helped the clients in the background, but I didn't want to add unnecessary and extra costs by sending a barrister to court as well. That could have added a couple of grand to the legal bill. So the judge was incredibly sympathetic to them, and they actually turned up at court with an amended claim. So they kind of, on the way to court, they'd seen that they needed to make amendments, and they had brought the claim wrongly. I suspect what happened is the solicitor, having brought the claim in order to try and intimidate our client into paying the loan, then instructed a barrister, and that barrister looked at the papers and thought, oh my God, we're going to have fun in court today. And yet he did a pretty good job, because the judge didn't actually make a costs order against them. He just told them to go away and bring their claim properly, and set a date by which, if they hadn't brought the amended claim properly, the claim would be struck out. So there's the facts of the case. In the process, my clients have racked up a legal bill of over £8,000, and I dare say our opponents have racked up a legal bill of the same amount of money. Now here's the thing, and just get to the meat of this vlog. If you bring a claim poorly and properly, if you don't do the work at the front end and make sure you brought it correctly, because I'm afraid to say the civil procedural rules, the Bible of civil litigation, are extremely, what's the word, it's like a chess rule book, or worse. They're extremely complicated, and if you don't know them intimately where certain cases are concerned, then you're liable to come a cropper. If you're bringing a claim, for a simple, let's say it's a simple debt claim not secured on a property and where there's no defence, no issue, then you could probably just bang off a claim form and get the ball rolling, yeah? But when you're sailing into the complex areas of claims brought against property, claims where there's a sophisticated defence, claims where there's an issue over whether it's Part 8 or Part 7, then you've got to be extremely careful as a litigant in person before you wade in. And I see a lot of people wading in, often litigants in person, and then they often call me in a bit too late in the day, like the fire engine, to put out the fire. Perhaps the fire engine isn't quite the right word. It's like they've laid the foundations to a house and start building the house, and I then have to come in and relay the foundations and get the claim properly on track. So anyway, the most critical thing here is there's a big loan, okay. There is, and we can't pretend there's not a big loan, although we've got a defence. And the defence is around the fact that they shouldn't have been adding interest over so many years, particularly when we'd made proposals. But as I say, it's a big claim, and yet really the focus is on the legal costs here, because if you bring a claim in improperly, you end up on the wrong end of not just your own solicitor's legal costs, because they'll have to now prepare a whole fresh claim. And so in other words, they will have doubled their own legal bill for not having got it right the first time. But they're also going to have to pay our legal costs. And here now is a little bit of a legal lesson, and I'll just link the relevant provisions of the CPR if anybody's faced with this situation themselves in the description box below. Here's the thing. If you are going to discontinue a claim because you're throwing the towel in and you accept it's been brought poorly, and there's no point in even amending it because it's been so poorly brought, then I'm afraid, under CPR Part 36, you have to pay the defendant's costs, legal costs, that have been occurred before and up until that point. and you have to actually file a notice of discontinuance with the court, and then that triggers the provision in CPR Part 36 whereby you have to pay your opponent's legal costs. Okay, so unfortunately, you know, they have threatened, obviously, to bring fresh proceedings, and they will bring fresh proceedings, but they need to have paid our legal costs first. So, you know, our opponent is faced with a legal bill of whatever it is, £15,000, £16,000 for this dog's dinner, the way that they brought this claim. Now, here's the other thing, and this is again why I'm, you know, trying to illustrate the point that where the matter is complex, unless you're intimately acquainted with the CPR, in other words, you're a lawyer or a very smart person, you are going to come a cropper. There's also buried in the civil procedure rules a little clause that says that if you are going to bring fresh proceedings that are materially based on the same facts by means of which you brought the first proceedings, you've got to get the permission of the court to do so. So you can't just discontinue and bring fresh proceedings when they're based on the same facts, which is now what our opponent is trying to do. So if they do, and this is a little bit why this litigation is like chess, because you've got to look a few moves ahead. If they do bring fresh proceedings, having not paid our legal costs of over £8,000, we will then apply to have that new claim struck out. And we will then, if they ignore us and they just bring the claim, it ends up at the strikeout hearing, because the strikeout hearing will happen at a very early stage of those proceedings. They will then not just have the historical legal bill that I've just referred to, but they'll have the costs of the strikeout application awarded against them. And here's the trick. When we make that application to strike out, in order to protect ourselves, we will simultaneously make them an offer. We will drop our strikeout application if you pay the costs of discontinuance, plus at that point the costs of preparation of the strikeout application. If they still ignore us, we get in front of a judge, and the judge says, well, look, here's the CPR, Mr. Opponent. It says that you should have paid the legal costs of your opponent when you discontinue. You didn't. It says that you should seek the permission of the court if you're going to bring fresh proceedings based on the same facts. You haven't. I have no choice. But to find against you and award costs of the strikeout application and the historical costs occasioned by discontinuance of the first sets of proceedings. And the judge may also say, I'm going to assess costs on an indemnity basis. And basically, there are two ways in which a court can assess costs, because you never usually in litigation get your whole costs awarded by a judge when you win. They usually knock them down because of the new rules on proportionality, but historically the costs have always been knocked down. And the knockdown approach is the standard basis. That's called the standard basis. But, as I say, a judge can take a view that the conduct of the opponent, the paying party of your costs, is such that they're going to make an award on an indemnity basis. They're going to give you your full costs. I won't go into the detail of it. It's not quite that simple, but broadly speaking, that is how it is. A standard basis, your costs are going to get knocked down. Indemnity basis, you're going to get your full costs. So there it is, a lesson learned. Our opponent is in a difficult position right now, because obviously I've laid this all out to them in correspondence. Because if they now bring fresh proceedings, they could be running into yet more heavy weather cost-wise. And now, before you blame the solicitors and you say to yourself, well, it was the solicitors, they were hopeless, he simply made a poor decision on which solicitors to use, I am going to rush to the defence of these solicitors, because I suspect that what has really happened here is the businessman has tried to get a result for a very low price. He has probably gone to his solicitors and said, not a reputable high-end solicitors, as cheap a solicitor he can find, perhaps, and said to them, look, I just need you to bring a claim. Clients are always asking me, can you just draft a letter? Can you just issue the claim? And that will scare the opponent and they'll end up coughing up. Yeah. And so the solicitors probably might have said, well, look, okay, we can do that for you. Okay, what's the price? I mean, this money is owed. So, it's just a case of writing a letter, isn't it? And just bringing a claim, isn't it? And the solicitor may want the business. It's a big claim. It's perhaps it's an important potential new client to them, and they do it for a price. They do a bit of a deal, and the pressure is on the solicitor to do it quickly and inexpensively. Now, you can cut corners in certain areas of law. If it's a very simple residential conveyance of a new build, if it's a very simple short will, you might even be able to use a non-lawyer, a legal executive or a paralegal. But where it's a big claim and where there's clearly some complexity, you're going to need to do some work. And your lawyer is going to need to drill into the law, into the procedural law, and that takes time. And that time obviously has a pounds, shilling and pence value. So I feel that what's probably happened in this instance is that they've offered some cheap legal advice in order to try and get the ball rolling, in order to please their client in the short term. But unfortunately, ultimately, the effect has been to create long-term problems, quite serious long-term problems for that client. I think about this particular case, you could say it's a case of being penny wise and pound foolish. Okay, thank you for tuning into this vlog. I will just make a final conclusion here that it's actually also handicapped their client, the businessman who lent the $60,000 in the first place. It's handicapped their client massively, because now his lawyers have tried once and failed, and they've now got to go back to court to get the matter back on track. I mean, he's probably thinking, jeepers, I haven't got a victory here, I haven't got the money back, and yet I'm having to cash flow litigation in what I believe is because obviously he believes it to be a cut and dried case. I lent the 60,000. Okay, interest is the complicating factor, but still, the 60,000. Why can't that be? Why haven't I got that? And unfortunately, you haven't got that because you simply haven't brought proceedings correctly. This is a classic case where you can be in the right in this type of case, and yet if you bring a claim half cocked, you end up having to empty your pockets on a road to nowhere. And actually, in this particular case, there is a defence under the unfair relationships test. So this matter could rattle on for a year or 2 years, and our opponent could end up having to cash flow litigation. Okay, well, I hope that illustrates the main thrust of this vlog, which is, if you're going to do it yourself, make sure you're properly prepared. If there's some complexity involved, then, as a lawyer, I would say this, but I mean this. You don't have to instruct a solicitor to formally represent you in those proceedings and conduct the litigation, but at the very least, do what is called an unbundled retainer with your lawyer, and just say, look, I just want you to look over my documents and give me some general advice so that I can keep costs down. Okay, thank you all for tuning in. Look forward to vlogging to you in the very near future. Bye for now.